big things in order for big things to come my way.
Brett's dad made that for you?
Oh yeah, I was gonna say I have lots of stupid things that Lynn does that I pay just like paltry amounts of money for. Every time he does something, I'm like, you do realize that if I like walked off the street and had somebody do this for me, it would cost me like thrice what he charges. But his gal, Kristen or whatever her name is, like their setup fees just dirt cheap. I think he does like most of the stuff for people I know. Like he does my stuff, he does Brett's stuff, obviously, Tom Teltor stuff. I mean, he does a whole bunch of people's stuff just because it's so cheap.
Tom's practice is a number.
Yeah, you know,
it's 524 legal.
I didn't really quite understand that one. But again, Tom Telthorst is an enigma wrapped up in a that dude is, yeah. There's a lot going on.
All right. We are, by the way, we are streaming live right now. So now that the paid commercial is over, let's start our we'll be on the record in case number 2020-CR324, caption State of Kansas versus Travis Sherman Kelley. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears virtually through Assistant District Attorney Adam Sokoloff.
May it please the court, Your Honor. Mr. Kelley appears in person via Zoom, along with his counsel, Dwight Alexander, via Zoom.
All right, Mr. Kelley, now we did the plea by Zoom. I remember back on June 4th. Yep. I'll ask you again, you know that we could do this personally if you wanted to assert your right to be personally present, but my understanding in talking to Mr. Alexander is you're okay going forward with Zoom and waiving your personal appearance in court. Is that correct?
Yes, sir.
All right. So like I said, there was a plea hearing back on June 4th. At that time, the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that, ordered a PSI and set it for sentencing today. I've received and reviewed that PSI. The critical findings are as follows. The primary offense of conviction is one of aggravated assault, a severity level 7 person felony. The defendant's criminal history score was found to be that of H. That would leave him with a presumptive prison. Well, there's also the special rule number 1, that this is a person felony committed with a firearm. Therefore, this is a presumptive prison case in which the presumed range would be 12, 13, or 14 months. If Mr. Kelley has to do that time, he'll be eligible to up to 20% good time credit and subject to a post-release supervision duration of 12 months. If he's granted probation today, it would be for a period of 24 months to community corrections. Mr. Sokoloff, I would ask you, did you get a chance to review the pre-sentence investigation? Do you have any additions, corrections, or challenges to those findings?
I have reviewed it, Your Honor, and I have no comment, correction, or amendment.
All right. Mr. Alexander, same question.
Your Honor, I've had an opportunity to read and review the PSI. We have no additions or corrections at this time. I believe that his criminal history score is appropriate at H.
All right, Mr. Kelley, I put up on the screen here that pre-sentence investigation I just talked about. Can you see that?
Yeah, I'm on a cell phone, so it's a little harder.
All right, just so you recognize that document, right?
Yeah.
All right, and Mr. Alexander is telling me he went over it with you, and particularly what I'm interested in is this criminal history worksheet that starts right there and then goes through that page.
All right.
I know I'm going a little fast, but I just want to know, did you have a chance to go over that with Mr. Alexander, and do you agree, as he stated, that it is accurate?
Yes.
All right, thank you. I will adopt the findings of the pre-sentence investigation for purposes of today's hearing. Mr. Alexander, you filed a motion for a downward dispositional departure. Would you like to be heard on that today?
Yes, Your Honor, please.
Please do.
Thank you, Your Honor. At this point in time, I would advise that my client, having a criminal history score of H and entering into a plea that was negotiated in good faith with the state, we'd ask that you depart to a probation finding and go outside of the scope of the special rule that applies in this matter. Mr. Kelley has not a very large criminal history and has accepted full responsibility for his actions by entering into a plea in this set of circumstances, by saving the taxpayers of Wyandotte County money as well as the time of the judiciary. And we would hope that in the totality of the circumstances, that would give the court enough reason to depart in this matter.
All right. Mr. Sokoloff, I will hear your comments on Mr. Alexander's motion and anything else you'd like me to know about this sentencing today.
Your Honor, I would echo the general sentiments of Mr. Alexander, and specifically I'd add that this deal was crafted with all of these things in various parts in mind, not just Mr. Kelley's stance in the universe, but the history of these parties. And I think Mr. Alexander might have hit the nail on the head at a previous hearing when he described it as perhaps a Hatfield and McCoy situation. And there are perhaps extenuating circumstances. The lack of history for Mr. Kelley is something that's meaningful here. Our legislature contemplates probation most times in a situation like this, but for a special rule, which is not by any means insignificant, we would be looking at probation. That special rule we're asking the court to not allow to be determinative here because we have hope that this was an anomalous mistake and that the prohibition from owning a firearm would prevent similar conduct in the future, not to mention just Mr. Kelley's willingness to do better. So all of those things considered, I'd ask us to score him in the box appropriately without the special rules being the determinative factor here. In the end, that's, we believe, the best hope for long-term success for our community.
All right. I'm assuming victim's been notified, doesn't wish to make a statement today.
That is true, Your Honor.
All right. And no request for restitution on his behalf?
There is no restitution in this matter, Your Honor.
All right. All right. Mr. Kelley, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
I've been doing good. I got a good job, and I'm just trying to strive to do better. I don't want this to really affect my life as it is right now. You know, so it's up to you, Judge.
All right. Thank you, Mr. Kelley. All right, Mr. Alexander, do you know any legal reason why I should not now proceed to sentence?
No, Your Honor.
All right. Well, I'm going to follow the plea agreement, grant the defendant's motion for a downward dispositional departure. I will adopt as the substantial and compelling reasons for that the allegations in the defendant's motion for a departure and the comments by both the state and defense counsel today. So therefore, the defendant will be sentenced to the standard term of 13 months in the Department of Corrections. If he has to do that time, he'll be eligible to 20% good time credit and subject to a post-release supervision duration of 12 months. His application for probation is considered and it is granted to community corrections for a period of 24 months. This is not a registration. Is this a registration offense given an aggravated assault with a deadly weapon?
Your Honor, the state is not asking the court to make the affirmative finding that would require such.
Okay, I think we went through that at the plea as well, correct?
Yes, Your Honor, and our interpretation has always been that despite the factual allegation, it requires an affirmative finding by the court, which the state is not asking the court to make.
All right, court declines to make that that finding today, so it's not a registrable offense. What do we know about jail time credit?
Forgive me, Your Honor. My blue horse is not responding. Let me see if I can get it to load.
Judge, from PSI set of circumstances, it advises in on April the 1st of 2020, out on June the 4th of 2020.
All right.
I have no reason to dispute that. Obviously, we'll give him full credit for the 2 months and a few days. That is.
All right. He'll be granted credit for all that. Make sure you guys can agree on what that is and then get it in the journal entry. All right. So you tell me, Mr. Kelley, you're working. If I ordered you to pay on court costs and such things $100 a month, would you be able to do that?
It will be kind of tight. I'm actually doing co-parenting. I'll have to pay for and going through this divorce. But I can do my best.
All right. How about I make it even at $50 a month? I think that
I could do that.
be able to get done before your probation's done. So I think that's what I'll do. You think you can make $50 a month?
Yeah, and any extra I can come up with, I'll pay that too.
All right. Remind me, Mr. Alexander, are you retained or appointed?
Appointed on this matter, Your Honor, and my fees are $460, I think.
All right. Well, here's what I'm going to do. I'm going to assess the court costs and supervision fees versus the defendant. And I'm going to the bids application fee, as well as $100 of Mr. Alexander's attorney's fees. That gives him somewhat of a break. So we're talking probably somewhere in the neighborhood of, this is a ballpark, Mr. Kelley, $600 or $700. So if you're paying that at $50 a month, you should be able to get that done before your probation is done. The order will be at a minimum $50 a month.
Okay.
The defendant to pay. All right. Mr. Kelley, you have 14 days from today to appeal anything you don't like about the sentence that you just received. You also may be able to seek expungement of this after a period of time following successful completion of probation. Mr. Alexander can tell you some more about that. And this may be something that you would want to get expunged off your record. So you may,
Yes, sir.
After you talk to him about it, you may set yourself a note or something that you'll remember when the time is up to file something to get that done. As a convicted felon, it is now prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically any knives that could be considered deadly weapons. I won't go through the whole list with you. My point is, before you decide to arm yourself with a weapon like that, make sure that you talk to a good lawyer like Mr. Alexander to make sure it wouldn't be a reason to revoke a probation or add new charges, okay?
Yeah, all I use is like a box knife at work. So that's
All
the
right.
most I own.
Gotcha. All right. So I also noted this is defendant's first felony conviction, so I will have to assess the KBI database DNA fee as well. So those are all done. Mr. Sokoloff, anything that I failed to cover today?
No, Your Honor, I don't believe so.
Mr. Alexander?
Judge, you got it all.
Okay. All right, Mr. Kelley. Here's what I want you to do. You're on probation with Community Corrections. I want you to call this number as soon as we hang up here, okay? It's
All right.
Can you write it down?
Yeah.
Area code 913
Uh-huh.
573
Okay.
4180.
Okay. I already filled out the paperwork and took it up to her and stuff too.
Oh, you have. Okay.
Yeah.
All right.
Yep.
Good deal. So you tell them we did your sentencing today, that you got probation to Community Corrections. They'll tell you when they want to see you. Okay.
Yeah, that's what she said. She said she'd get a hold of me once she talks to you guys or the district attorney or something. So.
Okay. Fantastic. Mr. Sokoloff, you needed something?
I was just remarking that I believe Megan had her hand up.
Yeah,
Okay.
I was just trying to see if maybe he was talking about the PSI writer that he gave the paperwork to.
That's my guess.
Yeah, so
Right.
it'll be a different person that you'll speak to for your probation, Mr.
Yeah.
Oh, all right.
Okay?
Yeah. So you call that number and just tell them you got sentenced today by Zoom and they told you to call in. They'll take your information and then they'll get back to you. Okay.
All right.
All right, Mr. Kelley, good luck to you. If there's nothing further, ladies and gentlemen, we will be adjourned.
Thank you, Judge.
Thank you, Judge.
Thank you.
You.